and they're almost like wild.
Okay, we call the meeting to order.
21 for 11.
We have a motion to approve the minutes of the last meeting. Motion made, seconded.
This is it?
All in favor?
Aye.
Aye, opposed, carried. Okay, the first item is request to approve the list of chargebacks and refunds. Let's see.
Oh, yeah.
The first two are just two different years, 14 and 15. The first two are chargebacks.
Mm-hmm.
And the assessment was incorrectly calculated, $275,000, and it should have been $239,500.
Okay.
And then the next two pages are refunds.
Okay.
And it does give explanations. They're in different towns. The first three are just 3 different years, and there was a $10,000 clerical error in the assessment by the assessor.
Mm-hmm.
And then there's the same for Queensberry. They're the same parcel, just 3 years.
Right.
And the value was never reduced from a Board of Assessment review decision that was done in 2006, but you can only go back 3 years.
Okay. So there's only really 3 properties involved.
Correct.
Okay. So we have a motion to approve the chargebacks and refunds. Motion made by Supervisor Molino.
He had actually made it.
He made it.
He seconded.
Oh, he did make it, okay, I didn't see it.
Sorry.
Okay. All in favor?
Aye.
Aye, opposed, carried. Okay, and then we've got Warrensburg parcel 211.17-2-43.2.
This is
Still
the
under review.
parcel, yeah, it's still under review. I actually was out and, posted some properties for the auction, and, we stopped and spoke to the lady. Her name is Larissa McKenney. She was home when we were there. She left it as she was going to speak to her attorney and let me know. We were just out there a week ago, so I figured I'd give her another week, to see if I hear back from her. Excuse me. She didn't sound overly interested in the property.
Mm-hmm.
You know, didn't really think she would have a use for the 6-foot strip. However, I did notice that the neighboring property, owned by a Charles Reynolds, it looked like they were mowing where it was anyways. I mean, there was some, looked like lilac bushes or something out by the road, but beyond that, there was just like almost like a fence post that laid there on the ground as a divider mark, and they were mowing right up to that. So it looks like the 6-foot strip was kind of being used by the other neighbor. So I figured we would kind of wait to hear back from her before we moved forward in any direction with it.
Okay, so after her though, then we go to this neighbor who's mowing it?
We could possibly consider that. The reason we went with Larissa McKenney was because it was originally part of her property. There was an error in the deed, way back. The deed actually called for 66 feet by 145 feet. And then when the deed came in and did a conveyance, the attorney only called it for 60 feet by 145. So it left out the 6-foot strip. Obviously, there wasn't ever a correction deed done, so it's never been corrected, and it caused a strip many years ago when we split that out.
Mm-hmm.
So we're kind of stuck with that strip. I don't know how easy it would be to merge it into that other piece of property. It never had any type of title going into that.
Never had any subdivision approval probably, right?
No. Nope, it was just an error in the deed that was never fixed,
Mm-hmm.
which created a split in the property
Mm-hmm.
for the March 1st status way back when this happened.
Right. It's not something that's really saleable to anyone other than the neighbor, sounds like.
Right, exactly.
So is committee okay with that? Just
I just have a
waiting to
question.
see what she does, and then we'll try the other neighbor.
This is a separate piece. We're
We
going to
try
talk
to
about.
claim by address
Okay.
for that, that sounds like.
I'm confused then.
That's the further down one.
You can't claim it.
Depends upon
What's the effect of that if he tries to claim against the county?
what we're.
Yeah, that's what I thought. Okay. Yes. So if we don't hear from that neighbor, then we go to the other neighbor and point out to him that this adverse possession try probably won't work.
No,
Okay.
I didn't think so.
Okay. Then we're on to another Warrensburg parcel, 211.13-3-35.
This is a property that last year, we considered taking on our foreclosure. There was two other pieces, the property that were owned by Westerly Acquisition behind this that we did actually foreclose on and sell at our, tax foreclosure auction last October. However, when we went out and inspected the properties, this property, was a garage of some sort, and in our records, we show that it was owned by a couple of oil companies prior. So we considered the possibility of contamination, so we did not wanna foreclose on it and take title to it and then there be an issue. So we have had some other discussion, we've spoke to, Mr. Garrity, and he provided us with a copy of a phase one that the town had done, but we would like to move forward and, try to take temporary incident of ownership, to be able to try to get in there and do our own phase one and go from there to see what needs to be done. I might wanna refer to Martin on that as to what we need to do to be able to do that.
Right, okay, Mark.
Mr. Chairman, it's a little bit more about the property. It's a quarter acre in size. As I understand it, it has a history of, as Lexi indicated, has a history of being owned and controlled by enterprises that are in the oil business. Able Energy of New York, A&B Oil Company, Oak Street Oil Company, all the way back to 1942. I have a copy of the Phase 1 report from Hanson and Van Vliet that Lexi referred to, that Mr. Garrity was kind enough, Chairman Garrity rather, was supervisor of the town, was kind enough to provide to us. That report, by the way, found no clear evidence of environmental contamination, but they did say, based upon their review, and given the historical use of the property,
Right.
that maybe a phase 2, soil sampling, would be warranted. That makes sense to me. It's a very well-written report. The problem with the report is it's 5 years old.
Right.
So what we'd like to do is, it was at my recommendation last year that we pulled this property out of the foreclosure proceeding. As I look back at my file, my further recommendation was to do exactly what we're asking to do today, and is to seek temporary incidents of ownership under that provision of the Environmental Conservation Law. We've done that before.
Right.
It's temporary. We don't acquire any liability. We get a court order within the context of our current foreclosure proceeding.
Right.
The court order allows us to enter upon the property for purposes of making environmental inspections. And then from that, a new Phase 1 report would be generated, and we would go from there as to what, measures might be necessary depending upon what our engineers recommend. We have a resolution that was passed some time ago that would indicate that we can go forward with these types of projects. They've given us a rate, I think it was $2,000. Jeff was going to check to see if that rate is still good. I hope it is, but
He did get that to us.
Okay.
He got that to me and let me know.
So that's what we're looking at. As you know, the treasurer has put a fund together. Mike, is that a environmental testing fund together?
Money in there to do this, yeah.
So
We're okay with that.
what we're looking for today is a motion from the committee to authorize council and the treasurer, the chairman if necessary, to move forward with an application to the court for temporary incidents of ownership so that we can conduct an environmental review, complete that review, and report back to the committee.
Okay, so I'd ask for a motion at this point. Oh, you got something else?
Would we also recommend to transfer the $2,000?
Mike, do you want to do that now?
Yeah, we might as well.
So
I'm assuming that the resolution will go through.
Okay. Motion by Supervisor Molino, second by Supervisor McDevitt.
I
I just have a question,
Okay.
Mr. Chairman.
Yep.
The phase one, as far as, let's assume we do a phase one study, and I guess I have two questions. Does a phase one get into the area of soil samples?
No.
It does not.
Just a record search, isn't it, basically?
Yeah, and what I would imagine, Mr. Supervisor, I would imagine that Clark Patterson Lee will take this phase one report, and listen, a lot of it's just, pages that I don't know what they mean, but a lot of this is just documentary evidence that they've acquired through their record search. That'll all have to be updated, and then they'll give us a recommendation. My bet is that their recommendation would be similar to what the Hanson Van Fleet recommendation is, and that's to suggest that soil sampling may be done. It's possible that based upon their phase one report, that they see some evidence of contamination that maybe has surfaced since Hanson and Van Fleet did their inspection 5 or 6 years ago. So that's another reason to do a phase one at this point in time, is for them to, physically walk around the property, get the lay of the land, if you will, and also do a record search.
We did a phase one, and it was questionable or not questionable. Would the payment of the phase two study, would that be included in the money that's available?
We have money to do
You
that,
do
yes.
a phase two.
Right.
Yeah, to do a phase two. And what we
Yeah.
do, like we're doing it on a couple of properties right now, we broke the phase two down into 2 phases, okay? To try to save a little bit of money as we can, but there is, I've got well over $100,000 in that testing fund, so we've got enough money to do the testing, on these properties. That was the whole purpose of setting this
Yeah.
fund up, so we can figure out what we've got and then move forward from there.
Right, yeah, so for many years, I recall being very frustrated before we had that fund, because we would just pull these properties out of the sale, and nothing would happen with them, and the owners, some of them had businesses, and they continue operating the businesses, and we don't want to foreclose, and they don't like paying taxes, so they didn't pay the taxes, so this is a much better way to handle it.
The classic is the one property in Johnsburg, the taxes haven't been paid since 1989.
We're in the process of doing the phase two
And we're
on
doing
that
phase two
now.
on that property right now. So we will know what's there, and we can move forward.
Right. Okay, any other questions or comments? If not, I'll call the question, all in favor?
Aye.
Opposed, carried. Okay, anything else, Lexi?
Yeah, just my parcel postings, we did go out, we had 25 properties that we hadn't gotten any answers on, so we did post those 25 properties. And also, as of this morning, there is still 221 parcels on the foreclosure list. Just a couple of notes, the last day for them to redeem is July 17th in the treasurer's office. And just for all of you to maybe note on your calendars,
Mhm.
the last chance meeting is August 10th,
Okay. Mhm.
which is the important one.
Is that about where we are at this stage, other years, that number of
It
parcels?
seems a little high to me.
We're high.
Yeah, that's what I thought.
We're high for this point, because we're just barely 3 weeks away from that, so we're a
Yeah.
little high.
Mhm.
Not worried.
Right.
But, on the other side of it, my staff is going nuts right now, because the phones haven't stopped ringing, and we're starting to get a lot of installments out, so.
Right.
Hopefully,
Mhm.
down.
Okay. Okay, any other business for the committee? If
That's
not,
it.
motion to adjourn. Made, seconded, all in favor?
Aye.
Good.